Woof! You sure gotta climb a lot of steps to get to the Supreme Court building here in Washington, but I wonder who that sad little scrap of paper is.
Hey, it's me, Michael.
Tom? Are you a bill? Just a bill sitting here on the Supreme Court building steps?
I ain't no bill. I'm a law boomer.
Wow, the Supreme Court, the impartial guardian of our liberties. Where would we be without it? The presidency, Congress, they'd be running roughshod all over our freedoms. Thank you, Supreme Court.
No, everything you just said is wrong. The Supreme Court is highly political, and most of what it does is by omission. It sits back and lets the federal government get away with pretty much whatever it wants.
Tom, I don't know that much about the Supreme Court. I was always taught that it's an impartial guardian of American liberties, and it's the branch of government that keeps the other two branches in line.
Actually, Michael, all three branches of the federal government have a responsibility to uphold the Constitution. But today we have this superstitious reverence toward the court, as if the court is uniquely positioned to protect us against abuse.
Hold on. The Supreme Court is not like the other two branches. They don't campaign. They're not politicians. They don't have a vested interest in an individual bill passing. They're there for life. So they're not subject to partisanship, and it has the word supreme, which means above the other two.
So you're basically repeating this comforting myth that we're all taught, but there is absolutely nothing to it. And remember, too, Thomas Jefferson taught that what we have in America is called concurrent review, that all three branches have a responsibility to uphold the Constitution. And even James Madison, in the report of 1800 that nobody reads anymore, says that in the last resort...
What does he mean, last resort?
He means that when even the courts have betrayed us, yes, even your Supreme Court, it falls to what he calls the constituent parts of the Union to defend the Constitution. What he meant by that? It's up to the states to stand up and resist abuses of power.
There's a reason the Supreme Court is the last of the three branches to take a look at a bill which has now become a law. They're like the goalies. They're the last step to keep a law that's unconstitutional from being implemented.
All right, Michael, now we're getting somewhere. If they're goalies, that means they play for a team. There have even been people sitting on the court who have wound up pursuing partisan political offices. For example, Charles Evans Hughes resigns from the bench to accept the Republican presidential nomination. But even beyond examples like that, when you play for a team, you're also playing for the league. We forget that although the Supreme Court every once in a while will side with you, the Supreme Court is part of the federal government. It's hardly an impartial arbiter. It's like if you and I were having a dispute and I said, now look, Michael, my mom is a really, really fair person. We'll take our dispute there. Well, it's not impossible that my mom might say, Tom, really, you were wrong in this case, but I highly doubt Michael would want to go into that arena.
You had Earl Warren. He had been the Republican vice presidential candidate. He'd been governor of California. Teddy Roosevelt's opponent in 1904, Alton Parker. He had been a judge. William Howard Taft went from the president who got stuck in the bathtub to Chief Justice of the Supreme Court. So historically speaking, there wasn't any pretense that these men were just politicians. They were partisan politicians. And in fact, to this day, every so often someone say, they should have appointed Hillary Clinton to the Supreme Court, or Barack Obama, or even Michelle Obama.
And just look at the way the Senate nomination hearings take place. That should make clear to anybody that none of these senators are looking for somebody who just has a solid knowledge of the law, who wants to apply it consistently and fairly. So if they ask about some particular legal theory, it's only because they think, if this person believes this theory, he'll probably support my whole legislative agenda. That's all this is about. So, Michael, returning to a level that even you can understand, let's talk about goalies again. Would you choose somebody from the other team to be your goalie?
I don't know, Tom. Could it be your mom? Tom, is that another bill sitting here on Capitol Hill?
No, you midwit, that's James Madison.
The basketball player?
The father of the Constitution?
The father of the Constitution?
Yeah.
Mr. Madison, why are you hanging around the Supreme Court?
Madison wrote a report in 1800 about what the states can do when the federal government overstepped its bounds. He said the parties to the Constitution, by which he meant the states, had the power and the right to judge whether the Constitution had been dangerously violated. And the states' rights to do that extend to violations by the president, violations by the Congress, and violations by the courts. And of course, today's view is that the states have no authority whatsoever, and whenever we get screwed by any branch, well, like good losers, we're supposed to sit back and take it. So nobody listens to James Madison anymore. Or they pretend to, or they put him up on a pedestal, but they never mention the Report of 1800.
Have you heard of this little something called the Civil War?
Well, actually, Michael, it's not quite that simple. The Civil War had to do with secession, and you can argue about that. But it did not address the question of what is the role of the states in the Union? Can they make judgments about constitutionality? We've seen that in our own day. State after state has legalized marijuana in complete defiance of the federal prohibition. And the tank's not exactly rolled in all these states. And the only time the Supreme Court has weighed in regarding medical marijuana, they sided, as usual, with the federal government, saying the states had no right to do this. And the states said, duly noted, and went ahead and did it. So the spirit of James Madison is actually still very much alive today.
So how did we get to this point? When did it change that the Supreme Court has gone from restraining the federal government to enabling it?
Well, almost right away. So let's talk about one of the cases that we're all taught to revere that was actually decided clearly incorrectly. McCulloch versus Maryland, 1819. Almost nobody remembers the particulars of the case. That's not the part that matters. What matters is what the Chief Justice, John Marshall, had to say about implied powers. And in that decision, we hear the Chief Justice telling us that of course the federal government has powers beyond the ones expressly delegated to it in the Constitution. Now, Marshall knows this is not right. He was in attendance in Virginia at the Richmond Convention that ratified the U.S. Constitution, and he heard with his own ears supporters of the Constitution assuring everyone that this government will have only the powers, quote, expressly delegated to it.
Tom, don't you think you're being a little unfair to John Marshall? No one cites those ratifying conventions. They're like a historical curiosity.
Because, of course, if we did return to consulting the ratifying conventions, we might have to scale back federal power, and they don't want that.
Okay, here's where we are. Republican, Democrat, Independent, whatever. Everyone agrees when it comes to the Supreme Court that it's gotten too partisan and too political. Every single Supreme Court nomination is a nuclear bloodbath. So what can we do? We're not going to get the Republicans to be less partisan. We're not going to get the Democrats to be less partisan. But what we can do is make each Supreme Court justice nomination not as big a deal. How do you do that? Well, here's a new idea that people have been floating around. You add more Supreme Court justices. Just like there's 435 people in the House, so each individual House race doesn't matter that much in totality. It doesn't have to be 9 Supreme Court justices. Now, lots of people have come forward endorsing this plan. Presidential candidates, prominent publications like the New York Times. So I'm not sure it's the right thing to do, but I am sure that this is a new idea that we should definitely consider.
Come on, Michael, even you have to know this is not a new idea. It was tried in the 1930s under Franklin Roosevelt. And by the way, he started it off completely dishonestly. He more or less said, "We have a lot of elderly justices on the court, and they're having a difficult time keeping up with the workload. So how about if I add an extra justice for everyone on the court who's over age 70 and doesn't retire?" Well, nobody really fell for that, and eventually he made things more or less clear by saying, in effect, "Look, I'm doing this because the people on the court have this old-fashioned jurisprudence." And in English, that means they're striking down my laws. They're striking down the Agricultural Adjustment Act, the National Industrial Recovery Act, and I fear they're going to strike down a lot more. So he came out and said, we're going to add a bunch of new justices. Now, even though the Democrats totally dominated both houses of Congress at that time, the idea still didn't get any traction. And in fact, the Senate Judiciary Committee, speaking about the court packing bill, spoke this way about it. "It is a measure which should be so emphatically rejected that its parallel will never again be presented to the free representatives of the free people of America."
So, if we're going to look at the Supreme Court as the final arbiter of what's constitutional, it seems pretty clear that having a president simply put in as many people as he wants that agree with him takes away the reason the Supreme Court's even there to begin with. In that case, it's not the judicial branch, it becomes the judicial department of the executive branch.
And then in that case, what's the point of having it at all?
What ends up happening is that the Supreme Court almost becomes like the president's cabinet. He or she gets a bunch of people that will do his bidding, pass them through Congress, and now they're there to rubber stamp his legislation.
And then in that case, whatever happened to your independent, impartial, judicial body?
Now, let's talk about a soccer game. What if the coach says, look, my team's not doing well here. We have to make sure that the playing field is adjusted accordingly. But instead of having a level playing field, you put the field at an angle, so all the soccer balls are going downhill toward your side. Is that fair? Is that reasonable? Is that looking at the law objectively and honestly? Or is it forcing an outcome that you would want to have happen, which is ostensibly not what the law and Supreme Court's supposed to be about? Just because you have a fire extinguisher in your house doesn't mean you should feel free to start fires to see how it plays out.
We're talking about the Supreme Court today because a lot of people think about it the wrong way. They think it's an impartial guardian of American liberties, that it prevents government overreach, and that maybe a good idea these days might be even to expand the court to include more justices, and this would lead to better outcomes. Every one of these things needs to be gently smashed.
It's funny, Tom. I guess people have two completely contradictory ideas in their minds all the time. One is that the Supreme Court is independent and objective and kind of the judge of the legislation passed and signed by the other two branches. But that they also understand that the Supreme Court might be the most hyper-partisan, hyper-political branches of all three, and a huge percentage of the votes for the presidency are based on who that person would nominate to the Supreme Court. Just because a man puts on a black dress, all of a sudden he's not supposed to be a partisan Republican or a hardcore leftist?
Stop. Hammer time.
Tom, what are you wearing?
The Supreme Court reinterpreted me.